Good afternoon, everybody, and welcome to today's webinar. We'll get started in just a moment, but before we do, as people join us, I've got a couple of parish notices to get through before we get into today's topics. The first of which is this week we are beginning our series of regional meetings with local authorities. If you remember, I promised we'd come back together in regional groups last autumn when we first got together, once we had the new guidance and once we had a draft of the revised pupil registration regulations to discuss. So the conversations on those in regional groups begin this week, the first of which is tomorrow in the southwest region. So if you attendance is limited to one person from each local authority, but if you are on the call today from local authorities in the southwest or in regions where we're having those conversations this week and you haven't signed up, if you can go back and chat to the team and decide who will represent your LA and sign up to those, please. It's the southwest tomorrow, followed by the London region on Wednesday, the northeast region on Thursday, and the Yorkshire and Humber region on Friday. The second notice is about our change in ministers. I'm sure nobody has escaped the news of the weekend and last week with changes in government. I just want to reassure colleagues who are attending today that it's business as usual in terms of school attendance. Progress with the guidance and the various consultations on attendance will continue, and the schools bill, which I know many of you are following in Parliament, remains in the House of Lords, and as many of you may know, removes to report stage in the House of Lords beginning tomorrow. The third is on the aforementioned attendance consultation on the pupil registration regulations and on the national thresholds for fixed penalty notices. That's available on Citizen Space, the Department's Citizen Space website, and it continues to run until the 29th of July. Really important that LA colleagues read and digest both the consultation document and the draft regulations and submit your views to that. We're very keen to have everyone's views on that. And the regional conversations that begin tomorrow will be another opportunity to do that, but please do fill in the online survey as well. And then finally, the fourth notice, as colleagues may remember, we had technical issues on the webinar about the overall LA attendance strategy, and I promised we would do a re-recording and put that onto YouTube. That's been delayed with various things, but the recording's taking place this week and it'll be available on there shortly. And what we'll do once it's live is we'll send a link round so that people have got that. We haven't forgotten about that. Super, let's get started then. I'm going to speak for slightly longer than I normally do today to cover in a bit more detail the legal intervention section of the new guidance, and I'm delighted to be joined by Claire Nichols from Durham County Council, and she's kindly joined me to talk through her decision-making form, and she's going to illustrate lots of the points that I'm going to talk about in how they do that and use that in Durham in a large unitary local authority, and how her team uses the full range of parental responsibility measures and chooses the most appropriate to suit the family and the individual circumstances of the family. Super. Can we go on to the next slide, please? Before we get into the detail then in terms of the legal intervention, just a reminder for those who are attending us for the first time today, new guidance was published back in May that sets out the expectations and responsibilities on schools, on multi-academy trusts and governing bodies, and on local authorities on attendance from September of this year. The guidance is part of a suite of measures that many of you will see the government is taking forward in terms of improving consistency of support for families across the country on attendance, and part of that is moving away from blanket punitive approaches and putting in place a model where support comes first, and where we prevent absence before it becomes problematic. We intervene and provide targeted support to families who need it to remove those barriers to absence as early as possible, and that we have better joined up working for persistently and severely absent pupils. And as I said, if anybody is following the progress of the schools bill, The government, as you will have seen, intends to make that guidance statutory. That won't happen until September of 2023 in terms of the guidance becoming statutory. But a reminder, and I've had some questions on this over email, that just because a guidance document isn't statutory doesn't mean that it can be ignored. The local authority must still have regard to it, and so you should still be putting these things in place from September of 2022, even though there's recognition that it will take time, and that September 2023 those things must be in place. Super. Next slide, please. As you will see when you delve into that guidance document, and those of you who've been with us in previous sessions will know, there are 3 overall responsibilities for attendance for the local authority. Those are based on effective practice in the local authorities, which have lower average rates of absence, plus high or higher than average levels of disadvantage, and what works well in those areas. And today we're focusing in on the second of those, again on the school attendance support team and the core functions that it will need to provide free of charge to all schools. And we're looking specifically at the last section of the attendance team's responsibility, the use of attendance legal intervention where support isn't successful, isn't engaged with, or isn't appropriate. Super. Next one, please. I think we've gone slightly wrong with the slides there. Isaac, could we go back a little bit? That one, super, thank you. So in terms of what the expectations are on local authorities and the local authority attendance support team on legal intervention, it's set out in detail on in paragraph 81 of the guidance, and essentially it makes the team responsible for liaising with schools and liaising with legal practitioners wherever they sit in the authority or partner agencies to take forward attendance legal intervention on individual cases where the voluntary support that we've talked about in previous sessions hasn't been successful or wasn't appropriate, for example in the case of a holiday. And underneath of that, it sets out 6 key responsibilities. The first of which, understanding and making use of the formal support options, so parenting contracts and education supervision orders, and using them fairly and freely and consistently across the authority. Secondly, setting out clearly for pupils, parents and schools when and how attendance legal intervention will be used, so they're clear when they are accessing that voluntary support, what will happen if that isn't successful or it isn't taken up. Thirdly, securing effective joint working between the attendance support team in the LA and the statutory social care teams within the local authority, and working together where there are safeguarding concerns or where absence becomes severe, and making use of the statutory routes that they have through section 17 children in need assessment or section 47 child protection assessments. And fourthly, building attendance expectations into those plans wherever appropriate in terms of children's social care, and developing and intensifying that formal support, such as through an education supervision order where it hasn't been effective or it isn't any longer sufficient. Next slide, please. Super. The 5th one there is about fixed penalty notices. The responsibility remains in the local authority to issue fixed penalty notices in line with codes of conduct where the absence has been unauthorised and where the support has been provided hasn't worked, hasn't been engaged with, or wasn't appropriate, such as in a holiday. And then finally, taking forward, of course, attendance prosecution as an absolute last resort where all those other routes, both voluntary support, formal support and the earlier legal parent responsibility measures have been exhausted or were deemed inappropriate. Next slide, please. Section 6 of the guidance then sets out in a bit more detail how attendance legal intervention should be used, and the big change in this guidance compared to previous ones is this move away, as I said at the beginning, from the blanket approach of use of legal intervention to individual case-by-case decisions, making use of the full range of measures that are available. So schools, trusts and LAs are all expected to work together and make use of the full range. A decision should be made in each individual case based on those individual circumstances of the family as to which measure is most likely to change the behaviour and improve the case, if any. And in making that decision, you should be clear that it will change the parental behaviour. They're called parent responsibility measures for a reason. And it's about which one of these is really going to make the difference and shift the parental behaviour. As this diagram on the slide shows, then, as we move towards prevention and early intervention, we should really see a decline in the number of cases that reach the stage where legal intervention is needed. That's key to the government's focus. So this diagram shows that and what we've been covering in recent weeks, that parents should always be helped to help themselves first and foremost through the voluntary support, such as a voluntary early help plan. If that isn't accepted or it doesn't work, you can then formalise that support through the parenting contract or through an education supervision order if you're not getting that parental engagement and a contract wouldn't work. And after those two options, you should then either move to statutory children's social care, as I say, section 17 or section 47, or to a fixed penalty notice or prosecution where it would change the behaviour in the family. The exception to that trajectory, of course, is that other types of penalty notice, such as those for holidays or where the pupil's found in a public place in the first 5 days of an exclusion, they shouldn't obviously follow that. They're used is the first instance. But in the rest of the cases, in the irregular attendance cases, try to follow the escalation of support. And if anybody caught Baroness Barron's speech in the committee stage of the schools bill a couple of weeks ago, she phrased it quite nicely. The government's position is support first, support second, support third, and support fourth, and only then do we look at the legal route. Next slide, please. Super. The specifics of the measures themselves remain the same. So they're set out in section 6 of the guidance. I'll recap a little bit about each of them in turn now, but many of you will know this. So for some people it's a refresher. For those of you who are new, it's a bit of an introduction, but I'm going to rattle through them in quite quick order. So if you're interested in any of the detail of them, go back to section 6 of the guidance and it's all there. But we'll begin with parenting contracts. And what I really want to stress in parenting contracts is these are not a punitive approach. Terming it as legal intervention and putting formal support around it doesn't necessarily mean it has to be punitive. It's taken forward from the point at which we've helped parents to help themselves and that hasn't worked, to where we are sitting down with them and saying we need to make that a more formal arrangement. So it is instead, of course, a written contract between school or local authority, and in many cases both, and the parent. The pupil should be involved in that as well if they're old enough to do so, and you should always explore a contract first before you move to an education supervision order or a prosecution. You might deem that it isn't appropriate in the individual case. That's fine. That's the point of the mantra today is going to be what would work for the individual family, case by case. As I said, the arrangement can be between the school or the LA and the parent, but it's likely to be both, and it's likely that both will have actions if you're following the new guidance correctly. And whichever party is acting as lead practitioner should lead. So as we've discussed in previous sessions, in many cases school will act as lead practitioner. There's no reason why they can't lead the contract, even if their point of contract in the attendance support team in the LA is helping and supporting in that. Every contract should contain details of the requirements that the parent is expected to comply with, details of the support that you as the LA, the school and any other services and partners are providing to help the parent to comply with that, and finally that formal statement by the parent that they agree to comply with its conditions for the period that it specifies. Those requirements might include things like attending meetings, participating or accessing support, accessing services or engaging in the reasonable adjustments that school or other parties have put in place as well. And that's a bit that people often forget. If school have put something in place like a report or a slightly reduced timetable in the interim period, that can all go into the contract as well. In terms of support, the things that you might pop in there could be the details of the lead practitioner and what the lead practitioner will do for them, the referrals to services and the commitment to refer or assess for various services, and of course more formal or time limited interventions like a parenting programme, time with the education psychologist or whatever. There isn't a formal minimum or maximum duration for the parenting contract, and that's deliberate in line with the individual case-by-case approach that the guidance advocates. It should be decided on the circumstances of the family, but most contracts tend to be between 3 and 12 months, but they can be longer, and of course they can be extended with parental consent if they need to be. Super. Next slide, please. In terms of education supervision orders, then, when the parenting contract hasn't been enough and isn't accessed or engaged with, or when you have had an early help plan and that hasn't quite worked and you need to give it some legal backing, those two routes could lead to an education supervision order, which remains an incredibly useful tool for the local authority to be able to provide that legal intervention and legal backing to get the parent engaged in the support, but without the threat of or need of having a criminal prosecution and going to magistrates court, as the order happens in the family court. And it gives the local authority a formal role in advising, helping and directing both pupil and parent to ensure that they receive their full-time, suitable and efficient education. In deciding then to go ahead with an order, the LA attendance support team needs to think about, have we explored every voluntary option? Have we exhausted them? And again, this point that I keep coming back to, would this order, is this the most appropriate thing? Would this order be the most beneficial for the family? Would it change what it needs to change for them? If there are safeguarding concerns and the lead practitioner is worried about them, you should always discuss them straight away, or the lead practitioner and their point of contact and support team can be involved in those, and you should always discuss them with children's social care and deciding again whether a social care route is more applicable, or whether there are things that can be done in school in discussion with the designated safeguarding need. If you decide that the education supervision order is the right route, when the order is granted, the parent's duty to secure their child's regular attendance is replaced with a duty to comply with the directions that the LA sets out, attending the meetings, getting their child into school, making use of the transport you've put on offer, that sort of thing. And that changes the level of responsibility. Schools can't act as the supervising officer, and a question that I often get asked is does the LA need to appoint a supervising officer? And the answer to that is yes, but that doesn't necessarily mean that that needs to be somebody from the attendance support team. It can be whoever that lead practitioner is. If the child's got a social worker, it will be the social worker. If they're open to early help, it will be that lead practitioner, or whoever else the lead practitioner is acting on behalf of. But schools and the attendance support team should work with the lead practitioner. This goes without saying, we've talked about this in previous sessions. Everybody should work together so that the family receives that one single point of contact, and that everybody behind the scenes, school, LA and other services, are working together to make the order a success. And where you've got that backstop of legal intervention, informal punitive legal intervention, I should say, if the order doesn't work, because if there's persistent failure, as many of you will know, to comply with the order, then the parent may be guilty of an offence, and you may decide to take that forward to magistrates court. At that point, and again I get lots of questions on this, but at that point children's social care should review the case again and decide whether the breaches alter the conditions and discussions that went on at the beginning in deciding that the order was the right thing, and whether now social care rather than magistrate prosecution is the correct route. Super. Next slide, please. As is hopefully becoming clear, and I keep saying it and I can't really stress it highly enough, the central aim of the guidance is to help the parents to help themselves, help the pupil to help themselves, and making sure that all the right types of support are in place, that we spot them early and that we get the help to people. And the point of all of that is, as we all know, attendance is or absence is habitual, and tackling the problem as early as possible will reduce the need for anybody to ever get to this point that we need to take forward prosecution. But where that does happen, the law will continue, and there's no change. The law continues to protect the child's right to a full-time education. So the LA retains its ability to prosecute in the magistrate as a last resort. When all those voluntary and formal support options have been exhausted. Where it is decided that you're going to take a case forward to prosecution, only the local authority can make that decision, and only the local authority can prosecute the parent. And in doing so, you're funding that action, including production of the court documents. Paragraph 119 of the guidance sets out some considerations that can help you make that decision, and Claire will say a little bit about some of them on her checklist, but the final decision, as I say, rests with the LA. They should be done on an individual case-by-case basis, and as always with this stuff, you should be thinking about and checking in on the Attorney General's guidelines for public prosecutors, considering the public interest, and considering all the duties you have under the Equalities Act. And also, just a reminder, an obvious point, but for those of you who are new, Section 444 of the 1996 Education Act sets out all the circumstances in which a pupil has not failed to attend irregularly, and where the parent hasn't committed an offence, when there have been absences, the statutory exemptions, as we call them, from prosecution. They're covered and summarised on page 41 of the guidance, but worth going back and looking at the original legal text as well. And then it's at the bottom here, it's worth pointing out that the prosecution must be laid before the court within 6 months of the alleged offence. Just a reminder of that for people. Try and have in the back of your mind when you think about these, the behavioural response again. So when the case is brought to court, Claire, I think I'll probably say a bit about this as well, but when the case is brought to court, what is the behavioural response that you're trying to get? And make sure that is built into the way you present your case to court. For example, if is going in there, setting out the facts and ending and coming out with a fine really going to make the difference? Or is it actually that you need the parent to engage? Is it that you need them to understand the severity of the issue? Is it that you need them to build their routine or whatever? And therefore are things like a community order or a parenting order more suitable in the case than coming out just with a fine? And set that out in the presentation that you make to the court, why you are applying to the court for that, and why you think the magistrate should grant that, and what you'd like to see that do. Super. Next one, please. Just a little bit on parenting orders then, while we're on the subject. I'm not going to say a great deal, but there are ancillary orders that the court can impose following the conviction. They sit alongside the fine and or the community order. They're not standalone. You can't swap the fine out for the parenting order, but you may wish to add that on and ask the court to consider it. Paragraphs 126 to 129 in the guidance give a bit further detail on parenting orders, but in short, they're a really useful way that you can request the court to put in place when there's non-compliance and when you're just not getting any engagement in terms of the support that's being offered. So for those cases, they're a helpful tool, and people who saw the series last year of webinars will remember all the benefits that Kirklees Borough had found in actually going in and saying to the court, this is what we want, and the progress that they'd seen in those families that weren't engaging at all before they put the order in place. Once that order's in place, it requires the parent to comply with those arrangements, and any breach of the order could be taken back to magistrate's court for a fine of up to £1,000. And as with the ESO, it needs a named responsible officer, and that person is listed on the order itself. Super. Next one, Isaac. The last one then is, of course, penalty notices, the most familiar to many of you. Fixed penalty notices can be issued where the pupil's absence wasn't authorised by the school and an offence has been committed. They're an out-of-court settlement, and they should be used where you think they're going to change the parent's behaviour. And where you think that they will, it's enough to make the parent secure their child's regular attendance in future. Like all of the others, there are cases where you won't want to have explored support first, like a holiday and term time, a very clear-cut case. But in cases of irregular attendance and unauthorised absence, you must think about the support first, and the focus of the guidance, as I say, is considering where the support options are, and only moving to fixed penalty notices where that hasn't worked and or it isn't appropriate, like in the holiday. The golden thread, as I say, on all of these measures, running throughout everything you do in forming the decision you're making here, is don't think about it in terms of, oh, well, we issue a penalty notice to everybody who misses this number of days. Think about it of, this child's got to this point, which is in line with our code of conduct. This is the support that we've offered. What other support could we do? These are the options that are available on the table. If that support doesn't work, is an education supervision order actually what this family needs, or is a parenting contract going to do it, rather than necessarily just a fine? But if you decide that a fine is the right approach, please follow the local code of conduct. I know people are starting to think about what the national framework might look like. We're in the process of developing and, as I say, consulting on those thresholds, but that won't happen before September of 2023. So stick to the existing rules that you've got now, and think about in those codes of conduct, are there any changes you need to make for the coming academic year 22-23 to really build in the support and the joint working elements that the new guidance expects. Super. I'm going to stop there then. And I'm going to bring Claire on. Claire will be familiar to some of you. She heads up the attendance team up in Durham, and she's going to say a little bit, as I said at the beginning, just saying how they go through this process of deciding on the individual cases. Over to you, Claire.
Thanks very much, Adam. So as Adam said, we've developed a tool locally to help us in very much in our decision-making process, following that kind of key investigation. So our approach locally is to consider each case on its own facts and merits, and also to make that process of decision-making as fair and objective as possible. It also helps us select the most proportionate, appropriate action based on the premises Adam's already talked about, such as which measure will make the most difference to improving attendance, because that's really what we're aiming for, isn't it? Which measure is most appropriate and suitable for an individual family, and which decision's most proportionate to the issues, and then running that decision making alongside the guidance contained within the Code for Crime Prosecutors. So very much viewing that through the lens of what evidence we might have and any potential public interest considerations that there might be. And also using this tool really to highlight any particular issues that we think are key to informing that decision making, and particularly if the decision were, say, prosecution, it's also helpful for highlighting those things that we really might want to highlight to the magistrates about how that decision's been made, or things that we really think are pertinent to, or were pertinent to that process of decision making that we would want to bring to their attention. And in using that tool, it might actually, and often does, opens up some further lines of inquiry that we might need to seek clarification on before we conclude a matter. So, and again, that obviously varies on a case-by-case basis. So this is this tool in front of that you can see. First of all, we'd consider any factors about the child or young person within that family, and there might be more than one. First off, so the age of the child or young person, and the time that they've got remaining in compulsory education. Any inclusion or behaviour issues, so we definitely would want to consider if there are any suspensions, exclusions in that particular offence period, any special education needs that the child might have, anything like the issues with school placement that have been brought to the school or our attention during that obviously that very informal part of the process, any issues with curriculum or placement difficulties. If it's a child with a social worker, that's either on a child protection plan or subject to child in need plan, that you would want to liaise with those relevant key professionals about their views as well on a decision, on our decision making, essentially to help us shape that, and obviously so that any action we might take is as dovetailed as possible with any other interventions that might be taking place for a family and any forward plans going forward. Whether attendance is affecting attainment, and we'd be surprised if it wasn't, if we're at the level obviously of legal action. So we'd want to know in what way, so that we can kind of build that holistic picture of that child's day-to-day life and how the non-attendance at school is affecting that young person, how it might be affecting that family and potentially the wider community, if that's appropriate, an appropriate consideration at that point for that young person. Socialisation, is it affecting a socialisation, or is it affecting the young person in any other ways, and what evidence have we got of that? Is that something that somebody has kind of just said, or is it, have we got that properly evidence that we could potentially use as part of our decision making if for example it were to be a legal case going through the magistrates court? What reasons have been provided for the absence? Obviously, in that early part of the process would have been really unpicking with alongside the school, particularly for our severely absent young people. What were those issues? I want to know really what they were and what actions have been taken to address those concerns, or any we've mentioned bullying there, but obviously there might be other reasons presented for absence, and the action that's not only being taken by school and agencies to address that, but the actions by the parent to resolve any issues as well, work on how they've worked alongside and engaged with the school and those agencies. Any child ill health issues, obviously mental anxiety concerns, any mental health difficulties, or any physical health issues, and whether the child wishes to return to education but has got insufficient support from the parent to achieve that. And we move on to looking at perhaps factors that are more associated with the parent. So things that might indicate higher or lower culpability, obviously using those magistrate sentencing guidelines, and so whether the parent has engaged, what they've done to try and rectify the issues, any collusion, and similarly any efforts to improve attendance, and perhaps why that's worked, not worked, or only partly worked, and so on, what the impact of that has been. Parental health, obviously mental health and physical health, parental learning disability or any special needs that parent may have, financial circumstances, is this a family in poverty? How much influence the parent has over the child, is the parent saying that the child is in effect beyond parental control? Are parents finding it difficult to make a change or unable to affect a change, and what is behind that? That's the type of thing we kind of be writing in there, and what evidence we might have of that. Is the dysfunction within the family that's not enabling them to solve the problem? And again, obviously, the school's approach there and interventions and the efforts of wider agencies, if they've been involved, obviously key to that. The level of parental cooperation, which I've touched on a few times here, but it's really obviously a parental engagement and child engagement, obviously a thread running throughout the other questions. But we're addressing it, giving it some focus here in particular. So considering their attendance at meetings that have been offered, adherence to any plans and targets, engagement with services. We've mentioned those other parental factors that we might want to consider there around any mental health difficulties or other difficulties that might be affecting their influence and capacity to influence change. Any siblings, and what the attendance of those siblings is. Is there any issues that kind of are affecting the family more widely? Is it the attendance of one child here, or is it 2 or 3 that's really potentially more pointing to a whole family concern? And any evidence of impact on them. It might be that the attendance of one child is having a really negative influence on the other. So we would want to unpick some of that and consider that as part of our process of decision making. Thank you. Would you mind just scrolling up a little bit so we could have a look at the case facts now, please? Thank you. So we'd want to know obviously what the level of attendance was during what period. Is it a relatively short offence period that might well be dealt with proportionately by a kind of perhaps less serious proportionate response, or is it a poor attendance across an extended period, like across the term? How much unauthorised absence is there present? How far below the persistent absence threshold are we talking about? Is it a severely absent pupil? Previous attendance history, is a parent or parents who are known to our service already, because we've had to take enforcement action around the attendance of a sibling who's already kind of left formal education, for example. Any other actions that we might take, and I guess we're looking at the case history to that point. We're looking at what school have tried, what agencies who might have been involved have tried, and really, if we're at that stage, why that has not had the impact that we'd hoped it to. And then obviously the effect of any potential action we might be considering. So, be kind of going through each one saying, well, would that have the desired effect? Is that proportionate to the offence though? And then we've got another sibling to consider here. Even though this child is close to leaving, and if we don't take any action, what might be the effect on that sibling, and so on. Any statutory defences, if we were considering prosecution through that section 4441 lens, was the transport issues, is the school within walking distance, any ill health, and so on and so forth. What evidence have we got of knowledge? Obviously particularly relevant if we might be considering a prosecution under section 4441A. Any evidence of there being any reasonable justifications that parent might have already brought to the school's attention or to agencies' attention, and how we've kind of sought to overcome those. Help offered to overcome those difficulties. Are there any gaps? Is there any areas where we think, if say we were considering a prosecution where we might be struggling to prove beyond all reasonable doubt, beyond a reasonable doubt, some there might be some gap that we absolutely find at this stage, and there shouldn't be, being really, really tight. But if there is a little gap, we might just want to ask a couple of questions to try and close that. And hopefully this decision making tool will help you really kind of look at where there might be further questions to be asked and to close any potential loopholes, so that we're really satisfied that our decision making is robust and based on obviously appropriate facts. And then lastly, considering is prosecution likely to have a long, or whatever action we're thinking of taking at that point, likely to have a long-term impact on attendance? Would, for example, a parenting order make a difference? Looking at any ancillary orders, would that child's welfare be adequately safeguarded? How much risk of further harm is there likely to be if, for example, we don't apply for an education supervision order? And then obviously just a little reminder for anybody looking at the tool of the duty to consider an education supervision order, either alongside a prosecution or obviously the duty to consider before obviously we take any action, but that also we can look at an order alongside any prosecution as well if we feel that that's relevant to do so. Okay, thank you. Could we just move on to the last page? So lastly, this is our decision making summary sheet. Look at obviously those with parental responsibility and what decision we were going to kind of arrive at potentially, and they're the main ones obviously that are available to us. Obviously we would check at this stage that when the child was last seen, have their views been considered, and so on. And then there's obviously, we make a decision and there's a final sign off and a check by another officer in team to make sure that decision making process has been applied fairly, proportionately and appropriately and in line with the code for Crown prosecutors. That's all from me, Adam, unless there's anything else.
No, that's super. Thank you, Claire. And I'm sure that's been incredibly helpful to colleagues and hopefully has illustrated many of the principles that I was talking about and what I know you all value, seeing what it looks like in practice in a worked example and how a local authority actually does some of those things. So thank you very much for giving up your time, Claire. Super. Should we move on to some questions then? Would you like to put some to Claire, Marcus, in the first instance?
Yeah, thanks, Adam. So we've got lots of questions, and most which you can see in the kind of the published bar. Unfortunately, we were not going to be able to get to all of them, but obviously we're going to get through as many as we can, and I'm going to do a bit of grouping just so we can cover as many. So, as Adam said, first is to you, Claire. So a simple one to start us off, which is, would you be happy to share your toolkit template?
Oh yes, of course. Yes, certainly. That I understand that will be made available alongside the slides afterwards.
Excellent, thank you very much. Second question then is around essentially how do you ensure consistency in completing this form?
Well, the fact that there is a template there, so everybody obviously uses the same one and then applies the same principles, but obviously each case is going to be very, very different. And obviously there's that second officer check as well, just to make sure that proper process has been applied. So obviously, you know, whilst we do apply consistency in how we make the decisions and in terms of the things we would consider, each case is going to be so bespoke and individual that, you know, I guess that second person there is there for that reason, for that double check to make sure that there's not huge variation in how people are applying that.
Excellent, thank you. And then final question for now, but if we have time, we'll come back to you. But final question is, I'll read it out with the questions at the end. Many of the cases referred to enforcement are ongoing historical regular attendance. To apply for an ESO, it requires the parent to engage. And this person has, after several parenting contracts, they've failed. So they're saying that they are not getting parental engagement. So you've kind of touched on this, but the question is, how would you deal with this, or how do you specifically deal with parental engagement or disengagement, I suppose?
I mean, that is one of the factors, as you've seen there on our kind of decision making tool is about engagement. And you know, if we do need an order obviously to secure engagement, then that would be very obvious at that point when we've looked at how the parent has already engaged and whether, you know, a particular measure might secure that engagement, how likely that's going to be moving forward, and therefore we might consider an ESO alongside prosecution if we really feel that both is required potentially.
And could I just add on that one, Marcus? And as I said, you know, parenting orders and community orders, when you're in magistrate, if it gets that far, are all routes to secure that engagement once you've got to that point. And many of your colleagues, I don't know who asked the question, but many of your colleagues will be able to share examples of where they've had positive outcomes in terms of community orders, where that was the bit that changed the difference, put the routine in place, or added the stability that was needed in the household. Thanks, Marcus. Was that it for Claire?
That's it for Claire for now, just aware of time, and obviously we want to cover as much as possible. So for you then, Adam, a couple, again, most of them are grouped for kind of clarity. So firstly, we've had a couple of questions on essentially who the ESO supervisor could be, and specifically if they can be school staff or that kind of thing.
Okay, I touched briefly on this in the presentation itself, but legally it has to be an officer of the local authority, so it can't be a school-based member of staff. It is the named supervisor. Somebody from the LA has to oversee it. That doesn't, as I said, have to be somebody from the attendance support team. If the lead practitioner in this individual case, in line with the guidance, is based in the local authority, in any of the teams, whether it's the housing officer, whether it's their early help key worker, whether it's a social worker, etc., then that person could act as the supervising officer. If it's something that the single point of contact for a school in your attendance team has agreed with the school, and school are acting as lead practitioner on the other elements of the case, then it may well be that it should be you in the attendance support team. But I want to stress what I said in the presentation, which whoever is the supervisor, they are not doing all of the work. They're not completing everything and delivering everything that's in it. They're supervising and overseeing the delivery of it on behalf of the local authority. But schools must pull their weight in that. Other services in the local authority and in partner agencies must pull their weight as part of the order. It's part of the principle of everybody working together in line with the title of the guidance.
Thank you. Next question then. Can we, or LAs presumably, apply for an ESO and prosecute the parent concurrently?
Yes, I think it would be rare that you'd need to do that, as Claire touched a little bit on this, didn't she? But there are occasions where you might want to have both running parallel. But as Claire also rightly pointed out, you must consider the ESO before you take forward to court, or in a magistrate's court case. So they would want to see why you hadn't thought at that point it was right to have try an education supervision order instead of prosecution. But if you've got to the point where you've prosecuted and you think an education supervision order should run alongside it, like Claire said, then you can have both. But both within the structure of the table in the guidance I showed you and in what would be required to be demonstrated in court, I think it would be pretty rare that you would need to do it in that particular out of sequence order.
Cool, thank you. Next question then. Can parenting contracts be shorter? Can be shorter, i.e. 6 weeks,
yes.
And possibly also
yes.
General thoughts on timeframes and periods?
Yes, they can be for whatever length. So we back to this individual principle. How long is the support that this family needs? Is it a 3-week contract? Is it to the rest of compulsory school age? Are we going to review it after, put it in place for 3 months and then review after 3 months? So whatever the order, whatever the need is, will determine the length. What I will say on that is you've got to build in those review points. So setting it miles in the future is not always sensible, but setting it in place for the next academic year, or as I said, the majority between 3 and 12 months, setting it in place for up to a year with review points gives the parent something achievable. And gives you a point at which you can discuss and decide whether you want to continue it. And you'll need to update and rewrite parts of the contract as the support and need diminishes or changes. So yeah, 3 weeks, 2 weeks, a year, however long the individual case needs.
Thank you. Okay, so next question then. Are ESOs and parenting orders to be used with pupils who have an EHCP, particularly when that EHCP covers school attendance until age 19? And kind of how would that work? And how would
So there's nothing to stop those measures being used with the parent for a pupil who's got an education, health and care plan, and that might be when you're looking at those individual circumstances, that might be the right thing for them. But it only goes up to 16, so it's only 5 to 16 and in compulsory school age. It doesn't cover post-compulsory school age, even though the education, health and care plan does. So the support provided at that point is different and slightly less formal, given the parental duty to secure that child's attendance isn't there at that point at 16, and it passes to the child. I just do want to say before we move on, Marcus, on education supervision orders, there was a question I spotted in the chat earlier when I had a brief scan about isn't this waiting a long time to start something, or why would I want to wait? You should be putting that support in place as soon as possible. You shouldn't be waiting to see what a period would look like. We've talked in previous sessions, haven't we, about how do we get schools to a position where they can identify that there's a problem and put all the support in place that they possibly can as soon as the pattern starts to develop? That's the focus of the guidance. And as your regular conversations take off between the LA and school, you're thinking about what needs to happen in some of the trickier cases in that. And you're putting that support in place as soon as possible. So no, you shouldn't wait until 3 months. You shouldn't wait 2 months. You should give the support when the support is needed. And the point of building that relationship and those regular conversations between schools and LAs is that there isn't those sorts of delays. So that's the overall principle. But then, if you heard Rotherham's recent presentation in the session on targeting support conversations. If not, go back and listen to that section. What they do, which is really useful and really important and a good learning point for everybody, is they put the support plan in place, regardless of which title it's going to have and regardless of which measure it's going to become. The support plan is drawn up in conjunction with the parent, in conjunction with school, and they've worked out what the barriers to attendance are, what help the family needs, what the local authority can provide, and what the school can provide, and what partner agencies need to provide. And that's offered to that parent as a voluntary offer in terms of an early help offer, or in terms of a team around the school approach. And then if they need to take that forward to court, you've got your draft parenting contract before you go to court, or you've got your draft education supervision order if you go to court, or you've got something that if it ever got to prosecution, you'd be saying, this is what I need help from the court to get the parent engaging. So the support should be you shouldn't be driven by the measures that are on the table, be driven by the case and what the case needs. And then these are your tools for helping that family to access that support. And then if they don't do that, ensuring that they access the support. Thanks, Mark. Sorry, that was a tangent.
No, that was literally going to be my next question.
Oh, good.
So
mind reading.
It's like we're seamless there. So last question for you for a little bit, and then I'll switch to Claire just to get coverage. And I've actually lost the question. Apologies. It's, as head teachers are still able to issue FPNs independently of the LA, what safeguards are there to ensure that the school has tried the informal and formal support that is expected to be carried out prior to the issue?
I can come in on that. I mean, in terms of the guidance is going to be clear, and is already clear in its non-statutory form, that the school must explore all of the support approaches first. It sets out how to do that. They should be having that regular conversation about you, so you shouldn't be seeing cases of people issuing a fixed penalty notice in an inappropriate situation. Where you do, you've got the opportunity to have that conversation about how that could have been different at the next targeting support conversation. As you know, and people who've already completed the consultation will know, part of the national framework, or the draft national framework proposals, is to ensure that all schools have to check with the local authority first before they issue a fixed penalty notice. So if you're seeing that or are still concerned about that, please do feed in to that consultation.
Excellent. Thank you. Okay, so Claire, I'm going to come.
I think we might have lost a bit of sound there.
Question for you, Claire, then, is who supervises ESOs in Durham?
So it would be our attendance improvement officers.
Amazing, thank you. And also apologies for the sound issue. And then second question, which is kind of a broad question, which Adam, you can come into afterwards, obviously, if you would like to, which is, so how does this work? All of it, really, the framework and the, the legal interventions. How does it work when we have no consent? So no children in need consent or early help and that kind of thing. And I specifically kind of, going into a bit of detail, I suppose.
I think you've probably said as much as you can on that one, Claire. I mean, it's back to what you said previously, which is you're exploring every option and you're making clear to the parent these are the benefits of engaging at this stage. We want to help you to help yourself. There's ways and means of having those conversations, and I've seen some absolutely dreadful correspondence letters and absolutely dreadful ways that local authorities put that conversation forward and that option forward to parents. But I've also seen some really brilliant ones, and there's everywhere in between. So it's thinking about how you put the offer in a compelling way that is clear that you are being supportive and you're being helpful, but that there is a set of consequences that come down the line if you don't choose that in a more supportive and non-threatening way than some people do, because what that can then cause is the parent to turn against and feel very isolated from the local authority, and then you're battling against a brick wall. That said, you've got those tools, and we've talked a bit about those tools, that if you're not getting engagement, to formalise and enforce that, and whether that's an education supervision order where you're requiring the parent to follow and take part in the support, or whether that is going forward to prosecution and seeking a parenting order or a community order that again requires them to do so. Have you got any examples, Claire? Or I'm sorry to put you on the spot, but I think you've said as much as you could before. But if you did have any examples that you've seen.
I think it's as you've already said, Adam. We absolutely make every available attempt to get parents to engage and to try and encourage that engagement through a wide range of agencies where we can, and using the total resource available. And if we can't do that, and we do have to use our legal intervention, then it's a matter of obviously explaining that to the court to say, what we do want is that engagement, and that would be reflected in terms of the type of I know obviously sentencing options are for the magistrates, but we would be highlighting that as a key point and saying, actually, we do really feel in this circumstance that a parent order would be appropriate in order to secure that engagement, and to set out some directions that we would like them to follow and instructions we would like them to follow.
Yeah. Super, thanks, Claire. And I think the other point that I just want to stress is parents of these pupils are struggling themselves in many cases, as well as the pupil with the barrier to attendance. As you all see on a daily basis, they don't understand often the legalese, and they don't understand how to navigate the systems and processes. So as well as the ways that you put it across, there is something about consistency and continuing to offer it, because it's very easy to say, oh no, I don't want to engage in that, and I don't need help on the first attempt, on the second attempt, on the third attempt. But it takes time for people to recognise that they need help with something. Their situation is live and changing and incredibly difficult in many cases. So you shouldn't give up, and you shouldn't say, oh well, they're not going to engage, so I'm not going to do anything more for that child. That's not the right attitude to have. Remember to continue and engaging in offering support and the options. But as I said before, it's also worth being clear that there are consequences at the end of the day if these routes aren't taken up in the first instance, and in doing so reminding them why, because so many people are frustrated by the need for attendance. You've seen the headlines, attendance above everything else. Why do we want 100% attendance? Do we not recognise that there are issues underneath of all of this? But people have to be reminded why individually their child needs that time in school, and what the benefits to their child is, and why you were giving them all of those chances and support and trying to put things in place. It isn't that you're coming after them and just putting a legal duty there. The legal duty exists for a really important reason, and remembering to remind people of that is really important. You saw quite a bit of change when you started to do some of that, Claire, didn't you? Is the sort of early help support and family stuff expanded in the east of Durham?
We did, definitely, and it's exactly as you've said there, Adam. It is about how you have those conversations and using that wider support of agencies to try and get everybody on board and make it absolutely everybody's business. And obviously I know everyone's working hard on that currently.
Yeah. Super. Well, thank you so much, Claire, and thank you to everybody else for taking the time to be with us this afternoon. Could we go on to the last slide, Isaac? If, as I say, I'll see some of you later this week as we begin those regional conversations, but until then, please stay safe. Thank you for everything you're continuing to do. I'm seeing some really, really amazing examples and people writing to me at the moment and saying how they've started to put changes in place and what their plans are for the year. And it's massively heartening to see the massive move in lots of local authorities across the country. We'll be back again next Monday the 18th at 4 p.m. Where I will be joined by colleagues from Northumberland County Council, and we're talking about attendance of pupils with a social worker. The link's in the chat, I believe, to in the questions section to sign up for that. And next week we have a second webinar on the Friday as well, where we're talking about the multi-agency support for families, and I'll be joined by colleagues from Dorset Council for that one as well. Until then, thank you everybody. Bye.